Welcome to Planning for Protection.
Hey everyone, welcome into an all-new episode of Planning for Protection with attorney Jeff Ryder. I am your host, Mike Leon. Jeff here is an elder law and estate planning attorney who's been serving families and aging adults all across Carroll County and the surrounding Indiana communities. Today's episode, we're going to be talking about what every Indiana seller and home buyer should know. Jeff, it's good to see you as always. Let's just jump right into this. Let me ask you, is it truly a gamble to sign an Indiana purchase agreement without legal review, or are these standard forms safe enough for somebody to just handle on their own?
Oh, that's a very good question, Mike. And by the way, thank you for having me. I appreciate the opportunity to be with you today. Is it a gamble? I think it depends. If it's a residential property, a house, and if you have a realtor, the realtor has a standard contract that is approved through the realtor board and is very standardized. And I think if you have that realtor and if you trust your realtor, I think it's probably not that risky to go ahead and sign the contract the realtor would provide. However, I sometimes see people who don't, for whatever reason, use a realtor and they want to just kind of write it on a napkin and sign it at the kitchen table. That can work, but it can also be a bad idea, and it leads to potentially unaddressed issues that will come back to haunt them. So in that situation, I highly recommend people at least consult with an attorney who deals with real estate so that they can get the I's dotted and the T's crossed and make sure that they're not unintentionally leaving open certain issues that would be better negotiated and decided as part of the contract process.
Yeah. Don't use a napkin, use a piece of paper, folks. I love the advice here. So Jeff, staying with that then, is that the biggest mistake you've seen people fall into in terms of like a legal trap where it's just like, oh, I can handle this on my own. Let's just sign this over a piece of paper. Like what's another common legal trap you've seen people fall into?
One thing that Indiana requires is a disclosure of the condition of the residence. And so sometimes people, for whatever reason, they shade the truth, it seems like, when they fill that out. And that's generally a very bad idea because, of course, if you sign it and then the buyer signs it and then it turns out to be very incorrect regarding certain aspects of the condition of the property, you're opening yourself up to litigation, which nobody really wants to be experiencing. So be candid and be truthful in your responses. And one of the options is do not know. And so if there's some doubt, that's what I encourage my clients to consider indicating, I don't know the answer to that, which at least, presents a defense if you are later sued for it. Another thing that the buyer can do is have an inspection of the property. And I think that's very often built into a contract where they've got so many days to arrange and have an inspection done. And then if there are issues disclosed on the inspection, then the parties can negotiate and or there's opportunity to negotiate the cost of whatever repairs might or might not be indicated on the inspection.
Yeah. Jeff, when you think of a contract, you think of a lot of fine print. Which specific sections, though, in a Indiana real estate contract kind of carry the highest risk if people don't understand them correctly?
Boy, this is self-serving to say to a degree, but in my experience, all the provisions are important. And while they don't always, occur, they occur often enough that they're there for a reason and they have meaning, and you should make sure you understand what they are. And if you don't understand, obviously ask questions and make sure you do understand. So I would say, I don't know that there's one single area that stands out the most. I think they all have meaning. They're all important, and that's why they're there.
Right. That's why you have a job, right, Jeff? To explain these to folks. So can I ask you something? You mentioned about the inspection before. How does let's go back to that. How does the Indiana law define this inspection period? What are some of the most frequent ways you've seen buyers and sellers maybe sometimes forfeit their rights during these negotiations accidentally?
Well, again, on a residence, there's a specific form that the state requires the seller to provide to the buyer, indicating their knowledge of the certain aspects of the property. And if you aren't truthful in that, then you can be held liable. The to protect the buyer, though, buyers very often schedule a inspection by a certified inspector, and that is, I think, a very good thing to do. The few times I've uh, purchased residences, I have obtained an inspector and had them review it, and that makes a lot of comfort for the buyer to know that, well, somebody who's trained in this area and is going to be able to stand behind it is telling me that yes, it's safe and good repair.
Yeah. Jeff, I've seen this before on TV shows where a real estate deal falls through and then both sides want to keep the deposit, right? In Indiana law, how does Indiana law dictate who gets the money in this dispute when it arises?
Well, that I've been involved in several of those disputes. Once actually in my own situation, and so if you if you can, I encourage you to reach agreement because nobody wants to end up in litigation, and there's always cost to litigation. And so, if you can negotiate it, I think it makes sense to try to do that. Usually, a realtor is going to be, if the realtor's involved, they'll be involved in settling the dispute about the deposit. And if there cannot be agreement reached, realtors are very quick to say, we're not going to get in the middle of this. We're going to pay it to the court, and then the court can decide.
Mhm.
Which, of course, is a way to resolve it, but it takes time and some cost involved. So that's why I encourage trying to reach a negotiated settlement if possible.
Yep, I agree with that. So let me ask you. Let's focus on the seller for a second. So a seller says yes to an offer. When does this legal clock start kicking in? What are some responsibilities maybe that catches the seller off guard during this escrow period?
Well, it's a in my experience, these contracts are very negotiable. I've had people say, possession as quick as possible is very important to me as a buyer. I want to close no later than 30 days. And so you've got to make sure the seller understands that and is prepared to vacate within 30 days. And oftentimes, people have possession as of the date of the closing. Occasionally, they'll negotiate for a later possession date, like 30 days after closing or 2 weeks after closing. I generally try have buyers try to avoid that because if they're paying for it, they want to get possession right away. But sellers sometimes don't aren't in a position to do that. So it's a matter of just getting a clear understanding of what your timeframes are and what the process is going to look like. And there can be a built-in rental period where the seller would pay the buyer rent for the additional time that they delay in delivering possession. And that rent can be accelerated if it's so much until a certain date, and then it can be accelerated much higher, if they stay longer than what they're supposed to. But it's not ideal to do that. So I encourage buyers to negotiate for immediate possession.
Yeah. Jeff, speaking of contracts and all this terminology, in your experience, and we were touching on it a second ago, but from the contract terms perspective, some of the things that you just outlined there, are those some of the biggest kind of red flags that you've seen that could potentially lead to future litigation? Like maybe a dreaded phone call that takes place, 6 months after your move-in date is scheduled. Like, what are some other red flags out there for people that are listening to this that they should be aware of on the contract terms?
I I am fortunate. I find myself dealing by and large with people of high integrity, and I don't see a lot of litigation in connection with real estate transactions. But that's partly because we try to get as much certainty and clarity as we can in the terms as we negotiate the deal to make sure that both sides understand what they need to do and what the expectations are and what the remedies are if they're not met. So we try to avoid those phone calls and litigation, and that's partly achieved by using a reputable title company, because the title company can search any liens that might exist against the property, any mortgages, any outstanding debts of the seller. And another option is to get a survey. Depending on the value of the property and the potential uncertainties of the lines, it's not unusual to require a survey to be done in connection with the purchase that will essentially guarantee where the property lines are and how many acres or square feet are being conveyed by the seller.
Right. Well, Jeff, as we land the plane on today's episode, the listener out there, one piece of advice you'd want them to take away from this, give them a golden rule here that every Indiana resident should follow before they ever actually put pen to paper on that Indiana real estate contract.
Well, that's a very good question. I think I would encourage people to spend what I think is a pretty modest amount of money to get somebody to review that. If there's not a realtor involved, and especially if it's not a residence on a particular lot, I think it would be very wise to get an attorney's opinion on the terms of the contract, the efficacy of the contract, and just make sure you're not leaving things unaddressed or undiscovered in the process of creating your deal on this real estate.
I know an attorney that can help. Jeff, thank you so much for the time and the insights. I appreciate it as always, my friend.
Thank you, Michael. I appreciate your time, and you have a great day.
That's it for today's episode of Planning for Protection. If you want to learn more, you want to connect with Jeff right now and his team, do me a favor, visit jriderlaw.com. One more favor as well before you go. Hit like, subscribe, leave a review, and comment or share the episode with someone who needs to hear it. I am Mike Leon. See everybody next time.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.